Well, I have got a paper, I sort of decided that let me write down what I want to say. Some of these ideas are in my book, while others are in the first book. Some are in the second book. But I want to do three things. The first is to talk about the emergence of private property during the colonial era. The second is to talk about how the resistance fighters came to accept private property in land, despite the apparent contradiction, and that private property had in fact been fueled by the colonists. And then the last thing is to critique private property in the modern context and to explore its economic, political, and legal justifications. The basic theory behind private property is expounded by John Locke, one of the primary British philosophers, in a document he published in 1669, the Second Treatise of Government. The essential thesis is that prior to the occupation of the land, at the time he was talking about the land of the Indians, the land was vacant, and as vacant land it was treated as terra nullius, terra meaning territory, nullius meaning no one. And his thesis was that occupation together with labor would produce ownership. So if you occupied and you were the first to occupy and you worked on the land, that would result in ownership. But his thesis did not regard the prior occupation and the prior labor of the Native American Indians. That thesis applied to South Africa as well. From the Cape through the Dutch East India Company, the same thesis applied. A different theorist, Hugo Grotius, but nevertheless a follower of John Locke's theories, served as the advisor to the Dutch East India Company, which expounded and applied the same thesis. John Locke's own history, however, sheds light on the justification for his thesis. John Locke was a shareholder in the Royal Africa Company, the company which was at the heart of the slave trade. It was, in fact, the Royal Africa Company that took the first slaves from Africa to Virginia in 1619. John Locke's financial interests also extended to the role that he played as the advisor to the British East India Company. For this reason, he has been described as no more than a theorist of empire. When the British settler colonial government first came to Southern Africa, it experimented with these ideas of terra nullius. But in reality, these were colonial fantasies of a few white men who came to settle in the new lands, the new territories. Terra nullius, in its most extreme form, was in fact never practiced either under the Roman Dutch system or indeed under the English law system. It was a tool seemingly devised only for the colonies. Nevertheless, the idea was widely held by the judges in the British colonies. Take, for instance, the comments of Chief Justice Rayner in Nigeria in 1898, where he says, "The next fact which it is important to bear in mind in order to understand the native land law is that the notion of individual ownership is quite foreign to native ideas. Land belongs to the community, the village, or the family, never to the individual. All the members of the community, village, or family have an equal right to the land, but in every case, the chief or headman or the community has charge of the land and sometimes is called the owner. Yet, what we know about actual customary practice is that while individual ownership to the exclusion of others was foreign, ownership as such was not. But there was distortion in Rayner's articulation of the customary law relationship to the land. Yet there were cases where ownership as such was held to exist but had been disrupted by the settlement of the British. Take another case coming 20 years after the pronouncement by Chief Justice Rayner in the Judicial Council called Re Southern Rhodesia. In that case, the court upheld the British wholesale expropriation of the entire territory of Southern Rhodesia, invaded by Cecil John Rhodes's company known as the British South Africa Company, under the mandate of the British Crown. That company had governed Southern Rhodesia for some 30 years after occupying and seizing the territory in the 1890s. But the legal dispute with the Crown arose in the run-up to self-government when the BCSA wanted to control the territory without the strictures of the British government. Its claim was to complete alienation of the land. But this was opposed on two fronts. One front was the claim of the native populations. The way the claim was framed in court was, does the land belong to the company or to the Crown? And there was no question about the land belonging to the natives. Why? The judge in the Privy Council explained, some tribes are so low in the scale of social organization that their usages and conceptions of rights and duties are not to be reconciled with the institutions or the legal idea of a civilized society. Such a gulf cannot be bridged. It would be idle to impute to such people some shadow of the rights known to our law, and then to transmute them into the substance of transferable rights of property as we know them. So the argument was, Africans are so low in the scale of civilization that ideas of ownership of property are foreign to them. The company's own argument rested on mining and land concessions it had obtained from Lobengula, king of the Ndebele. And Lobengula's own sovereignty was a convenient fiction that ultimately ignored the indigenous political structures that existed prior in the territory. When Lobengula signed the so-called root concession presented to him by the company representatives in 1888, in reality with an X, or as the contract shows, annotated as his mark, he was given assurances that no more than 10 white men would enter the territory and that they would abide by local laws. Later, he realized that he had been duped into granting concessions to the company. And his putative sovereignty over the land proved insufficient to rescind the agreements that had been signed. After the war broke out in 1893, really instigated by the British, Lobengula's own consent was no longer relevant. How did the court then deal with native title? The position as adopted by Lord Sumner was simple. Whoever now owns the unalienated lands, the natives do not. And the Privy Council on this basis ruled against the company, declaring that all the land belongs to the Crown. And the company itself is entitled to compensation for the concessions, some 3.7 million rands, 3.7 million pounds was paid to them. Although no violence was involved, even legal agreements like a lease could result in an alienation of land to the British settler administration. This is what happened, and this is the third instance in the case of Swaziland. Take Sobuza versus Alistair Miller and others, 1923 case. What had happened there is that King Mbanzeni of the Swazis had granted a concession under a lease agreement to two land agents, Thoban and Watkins. And this was rental of £50 per annum for a period of 50 years. Thoban and Watkins had agreed to respect all prior existing rights and not to interfere with the rights of the native subjects of Swaziland. In exchange, the king undertook to protect the concessionaires in the exercise of their rights under the agreement. But the problem arose when Thoban and Watkins began to evict Swazis from the land. The person who had negotiated the concessions on their behalf was one Alistair Miller, who doubled as advisor to King Mbanzini, and it was he who carried out the evictions. He had been asked to do this by Thoban and Watkins as the concessionaires. The Privy Council posed the question thus: what is the meaning of a protectorate? In answering the question, it noted that a manifestation by orders in council of the intention of the Crown to exercise full dominion over the lands which are unallotted is sufficient for the establishment of complete power. As such, notions of individual ownership are foreign to natives. Land belongs to the community, not to the individual. The title of native community takes the form of a usufructuary right, that is a right of occupation, a mere qualification, but never complete title. This right of usufruct or land use, the court held, may be extinguished by the action of a paramount power which assumes possession or control of the entire land. By this act, the British had completed the deprivation of the notion of ownership in land. What began as a distortion ended up as subjugation. Since the British did not recognize ownership by the local native population, they began to use the promise of political rights to attract resistance fighters to transform their thinking into a European mode. The Cape so-called liberal tradition held that everybody could vote, regardless of race. Yet, this was a deception. The qualification for franchise was property, but Africans were denied property rights. Since franchise was tied up to property, the two were perceived as indivisible. The premise for qualified franchise was generally accepted. Property and education, the symbols of civilization, were accepted by native leaders as necessary qualifications for franchise. As civilized men, the educated, property-owning African elite of the time could vote, just like their European counterparts. When the draft South African Bill of 1909 was published for comments, the South African Native Convention, comprised of the leading enlightened men of the era, constituted themselves. This is how they explained property ownership. They regarded this as a principle which was sustained by the leading statesmen of the country, and which was also the constant motto of the late Cecil John Rhodes. So they themselves not only accepted the basis for the qualification of franchise, but they embraced fully the notions propounded by Cecil John Rhodes himself. What was that? Equal rights for all civilized men, from the Cape to the Zambezi. Some 10 years after the passing of the Native Land Act, the South African Native National Congress, we know that today as the ANC, produced its African Bill of Rights for South Africa, which contained a statement of 5 rights to be included in the Bill of Rights. One of those rights was the right to unrestricted ownership of land, in this, the land of their birth. This Bill of Rights would later serve as a rallying point for further demands concerning inclusion into the structure of the South African government and the shared occupation of the land. No longer claims for the return of the land, but shared occupation of the land. Shared occupation along the lines of private property, which had now been accepted as a basis for liberation, also accepted as a basis for dignity. There is, however, a sense of despair in the 1923 Bill of Rights drawn by the ANC. It seems that the legitimacy of the British settler state is accepted beyond question. Africans now demand inclusion within the colonial paradigm. But there is an inspiration and aspiration too. While the British are rightly presented as among the greatest powers of the world, it is the source of this greatness that is intriguing. Africans now seem to assert that the British acquired the status of greatness not through pillage and plunder, but through justice and equality. Arguably, the most important petition of the era was produced in 1909 by some of the most thoughtful men of the time, William Schreiner, Abdullah Abdurrahman, John Tengo Jabavu. This would ultimately be presented to the British House of Commons. It is perhaps the clearest explanation of the African demands of the time. This is how it was put. Your petitioners, Your Majesty, are deeply disappointed at the non-extension of political and civil rights and privileges to the colored people and the natives of the Transvaal and Orange River Colony. They claimed that race could not be used as a basis for the extension of voting rights. But for the purposes of my talk today, they accepted that private property ownership in land could be used as a basis for the exclusion from the voters' roll. And so they proposed a new policy. And that policy included buying the land in exchange for acquiring the right to vote. And a new demand was inserted. And that demand was the demand for the right to buy the land. This is the greatest paradox of the struggle. That the right to buy the land had now become a key demand of the struggle. This was not only an ANC aberration. This view was widely held among the Africans of the time. Take the Imvo Zabantsundu newspaper article published on the 19th of March, 1912, recording the deliberations of the Cape Peninsula Native Association in relation to the draft Natives Land Bill. It rejected the bill as unjust, tyrannical, and designed to benefit mine and farm workers. But like the ANC had done, they too did not oppose the principle of buying land which was once theirs. This is how they put it. No provision was made for the old age, and no consideration was shown to them whatsoever. Africans had been content to remain on the land, well assured that what labor they were still capable of would provide for their simple wants. As Africans, they protested. They were willing, perfectly willing to pay, and asked only that they should be left in peace to continue to the end the work that they had served apprenticeship to. This demand, the demand for the right to buy land, persisted long after the passing of the Natives Land Act. The ANC's petition to the Prime Minister of South Africa, General Louis Botha, echoed this view. After explaining the hardships caused by the act, the solution proposed by the ANC was not the wholesale scrapping of the Native Land Act. Rather, quote, your petitioner, sir, humbly protests against the summary prohibition of the sale to natives and prays that you, sir, may exercise your power to bring about an amendment that there may be no prohibition to the sale of land to natives. When the Natives Land Act was eventually passed in 1913, the government of Louis Botha had promised to investigate the possibility of granting more land to Africans. In fact, the act itself contained a provision which allowed the government to give permission for natives to acquire land. Many natives did so, including one of the leaders of the ANC of the time, Pixley Ka-Izaka Seme at Dagakra. The property still belongs to the organization that he founded. The basic premises of the act, the unfair division of land between native and European areas, and the prohibition of the right to purchase the land were not changed. Instead, certain areas mentioned in a schedule to the act were proposed as areas where Africans could purchase land, thus marginally increasing the areas available for African purchase. Even one of the intellectuals of the era, Solomon Tekiso, who produced his formidable work, Native Life in South Africa, in 1916, did not argue against the principle of private property ownership. His argument was that it was unfair that black people could not access and own arable land. He argued that the Crown should protect black-owned land and specifically the inheritance owed to black people. Plaatje showed that the act forced people into reserves and imposed anti-squatting laws that caused black people great losses in land, livestock, and agriculture. He felt that all of this was unjust, but his solution was to abolish the prohibition on native acquisition of land. And so, by the 1920s, the demand was for the freedom to buy land. Later policy statements did not change this. The African Claims Document of 1941, even the Freedom Charter itself of 1955 did not change this demand. The focus, therefore, was the removal of the color bar in land acquisition. ANC policy on private ownership has not undergone fundamental changes since the days of the Charter. Its current position, expressed in the Constitution, is also premised on this idea of private property. The new Constitution also did not disrupt private property. In fact, it cemented it. Its premise is private property ownership in land. What has changed are justifications for it. Now we are told private property ownership in land is a basis for commerce. Take the comments made by Henry Louis Gates, not about South Africa, but America, who once observed that for African Americans, property was not just a symbol of prosperity and security. Instead, building a property-owning class is the key to ending racial inequality. Ending discrimination by itself, he argued, would not eradicate black poverty and dysfunction. What is needed, he stated, is an intervention to promulgate a middle-class ethic of success. And what might this intervention look like? He thought it was simple. Give property to the people who were once defined as property. And that is, as Louis Gates argued, people who own property feel a sense of ownership in their future and in their society. They study, they save, they work, they strive, and they vote. And people trapped in a culture of tenancy do not. Professor Ruth Hall and Tembeka Ngcukaitobi have also noted that in our own land reform program, private ownership is seen as the most desirable form of tenure. For policymakers, private ownership with registered title deeds, they argued, seems to constitute the gold standard for land tenure. In fact, our entire land reform policy is premised on the idea that land is to be individually owned in absolute terms to the exclusion of non-owners. William Blackstone once explained that the right to property is that sole and despotic dominion which one man claims and exercises over the external things of the world in total exclusion of the right of any other individual in the universe. Although Louis Gates laundered freehold as the key to financial prosperity, he was by no means the first. In 2000, Hernando de Soto, a Peruvian economist, wrote the book Mystery of Capital: Why Capitalism Triumphs in the West and Fails Everywhere Else. His thesis was that capital markets had failed in the developing world because many do not hold formally registered title to the land. Instead, they hold land through informal means such as communal associations. Lack of formal title, he argued, prevents people from using property as collateral, and therefore they are unable to unlock the capital which is to be found in land. Capital in land, in this sense, he argued, is mysterious. It works for some and not for the majority. The distinguishing feature is that some hold formal title and others do not. For those who do not hold formal title, land is dead capital. By registering it formally, it can be activated into productive capital, which can be traded in free markets. This way, many can be lifted from poverty. That may be so for some, but not so for the many. And South Africa's experience with the formal titling model has, however, not shown that De Soto's theory is true. We have been unable to convert land from dead capital into productive capital. To be sure, South Africa also follows the formal titling model, ensuring absolute protection for those who hold land, either communally or individually. But when experts subjected De Soto's theory to the test, it was found wanting. Remember, this theory depends on two assumptions. Assumption one is that private property can be held in formal title to the exclusion of others. Assumption two is that banks, and that's the productive element of this, will lend to people who can produce title, which can be used to serve as collateral. But in Joe Slovo Park, this was found not to be so. In that case, many people had occupied the land illegally. They had built approximately 5,000 informal houses. The government tried to formalize the occupation, building 900 houses. But unlike De Soto's thesis, this did not improve tenure or lead to financial prosperity. What the researchers wrote was the following. Whereas previously, family members had tenure rights linked to kinship and responsibilities, ownership was now registered in the name of only one member of each household, usually the man. This reduced the security for women and other members of the extended family, as the owner, quote unquote, could claim legal rights to use and dispose of the property as they wish. Instead, there were greater levels of poverty. One, municipal services had to be paid, yet there was no income. This worsening financial position of the new households resulted in the sale of some of the houses through informal systems, which were not themselves registered. What many discovered was that banks prefer income and not a piece of paper. The worship of title deeds, nevertheless, as the holy grail for land reform, has also been aggressively fueled by the state. In May 2018, President Cyril Ramaphosa launched what he called Title Deed Fridays. I think most of you must have seen that. He envisaged that 11,000 title deeds would be handed to qualifying beneficiaries. He extolled the importance of title deeds on the basis that a house is the most important asset that one can own. He located the title deeds in the economy of the country in these words: handing over title deeds to people would infuse growth in the economy because people would own something they could use as collateral at financial services institutions. It was as if he only read De Soto and never read local research about DeSoto's theory in Joe Slovo. So this idea of private property has also transcended beyond houses into farmland. In 2002, the state approved what they refer to as the Land Redistribution and Agricultural Development Program. One of its aims was to assist aspirant farmers with finances to purchase or lease farms. But take the case of David Rachase, who was a farmer, but no land in his name. He applied for funding, but after that application, typically he was subjected to a bureaucratic rigmarole until he went to court. But in court papers, the government confessed its policy. State funding, it explains, was primarily intended to assist applicants to acquire farmland, and the policy promoted the acquisition of privately owned commercial agricultural land. When the state funding is used to acquire farms, they said, the price is usually market related. So they confirm two aspects. First is the state's adherence to the private property paradigm. The second is the state's adherence to market fundamentalism. And so, as we can now see, if there is a land pyramid in South Africa, no doubt private title, freehold, sits at the top. Its economic strength lies in the perception, even though not the reality, of security. The view is widely held that capital can be raised at the back of freehold if it has sufficient security. Its practical value lies in the complete protection against any possible removal and the total control over each and every right attached to the land. Restrictions to private ownership, and there tends to be few of them, are limited to municipal laws, states' interests, and community-based laws. But otherwise, the owner is fully entitled to do pretty much as he wishes with land held in freehold. The legal standing of freehold is one of the few surviving laws of the colonial era, the Deeds Registry Act of 1937. According to this act, land can be transferred by the registrar of deeds, but it can be transferred by the registrar in these terms. The ownership of land may be conveyed from one person to another only by means of a deed of transfer executed or attested by the registrar. The legal effect of freehold is perpetual and exclusive, and there are no limitations to ownership. You decide who comes and goes from your property. And it is claimed that the utility of freehold is the relative clarity of rights. And yet it is in this clarity that negative elements can be seen. It is an absolute right which excludes others whose names are not reflected in the deeds of transfer. Problems of exclusion arise, for instance, in a marriage context where the property is registered in the name of one spouse and not the other. There may also be problems in a family setting if a property is registered in the name of one sibling to the exclusion of other siblings. These are inevitable features of an economically unequal society where economic power is both gendered and racialized. Beyond family, communal settings also bring about negative sides to freehold. If land is held on a communal basis with a chief or traditional leader as head of the community, should the land be registered in the name of the traditional leader? This is certainly the view held by Controlesa, recently expressed by Chief Olomisa. If it is, how should the rights of other members in the traditional community be defined? Traditional leaders have been known to alienate or lease community land without consultation or consent with the other members of the community. If title to the land is in their exclusive names, freehold rights would appear to allow them to exercise the rights of ownership, which any owner, including the right to evict from property. All of this seems to conflict with the fundamental basis of the constitutional dispensation, justice and equity. So as I close, private property once had its shrine. It once had its law. It was imposed by the British it was initially resisted. Yet, once it was linked to franchise, its fundamental status changed. African leaders internalized the idea as a symbol of civilization, access to political recognition, and personal status. Some influential commentators perceive it as a vehicle towards economic prosperity. The evidence to support the link between title and economic progress is dubious at best. Credit is not automatically available on mere production of a piece of paper. Regular income seems to play a much more important role in lending practices by the banks. Yet our land reform program continues to regard title as the preeminent vehicle for the return of the land. Perhaps it is time to lift our gaze beyond the private property paradigm. It has now lost its shine. Thank you.